When negotiating your medical malpractice case, if the defense makes a settlement offer and you reject it and you refuse it, will the defense revoke and refuse to make that offer again? You want to know the answer? Come join me on this walk as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, you sued your doctor for medical malpractice. Your doctor denies all of your allegations. You claim that your doctor was careless, causing you significant harm and injury. Your doctor says, I did nothing wrong, and even if I did, whatever I did didn't cause you injury. And then he says, even if I did cause you injury, your injuries really aren't as bad as you claim them to be. So now what does that mean? It means your case goes through the entire litigation process, and now your case is approaching trial. About a month or two before trial, the defense turns around and decides, you know what? We realize it's time to try and negotiate. We should try and settle this case. They make an offer to settle your case. Your attorney calls you up and says, hey, Jim, listen, I just want to let you know the defense has made an offer to settle your case. They've given you X number of dollars if you settle this case right now. You are outraged. You are furious. You are angry. Why? Because you are so upset that it's taken the defense more than 2 years to recognize and acknowledge that what they did was wrong. It's taken them so long to admit and acknowledge that your injuries have a particular value. And now that they've actually acknowledged and admitted that your case has a value that should be settled, you are outraged. Why? At the amount of money that they have offered. So what do? You turn around and tell your attorney, under no circumstance will I accept that offer. That offer is outrageous. It's insulting. Tell them to go take a hike. Or you use some other choice words. Okay, so now your attorney goes back and says, thank you, but no, we are rejecting your offer. And now there's no counteroffer. You don't want to make a counteroffer. You want them to pay. You want them to pay with every single penny that they have. So you give instructions to your attorney that you're not going to settle this case now. And maybe, if things go well at trial, you may turn around and try and negotiate then. But until then, you don't want to have any further discussions. So what happens next? What happens next is that now, as your case is approaching trial, your attorney has to get your case ramped up and ready for trial. What happens after that? What happens after that is that now you have to get prepared for trial. Your attorney has to go through the types of questions you are going to be asked, that he's going to be asking you, as well as the questions that you are going to be asked by the opposing attorney during cross-examination. You will have to be in court each and every day, sitting and listening to all the testimony. If that means sitting there for 6 weeks straight, it means you've got to sit there for 6 weeks straight. So now, as you're going through this preparation process with your attorney, you're beginning to recognize that, hey, you didn't sign up for this. This is too involved. This is too time intensive. You do not want to go through this entire process. It is ridiculous. It's taking time away from your family, away from your work, and now this is just too much. You call your attorney up and you say, listen, I've had a change of heart. I want to go ahead and accept the defense's offer. I realize I was upset before. I realize I rejected it in haste. Can you go back now and accept their offer? So now your attorney tells you there could be a problem. What's the problem? The problem is that this attorney and this insurance company made it very clear that if we did not accept their offer at that time, they would be withdrawing and revoking the offer and not making it again. You turn around and say, wait a second, how could they do that? How could they make an offer, a substantial offer, even though I didn't think it was appropriate? How could they take that offer off the table? And the answer is, that is a negotiating strategy. There's some defense attorneys and some insurance companies who use that as a negotiating strategy. They say, listen, this offer is valid only for the following few days or only till next week. And now if you don't accept it, we are taking that offer off the table and now we'll see you at trial. In that instance, if your attorney were then to go back to them and say, hey, listen, is that offer still on the table? In this scenario that I've given you, this example, the answer would be no, that offer is no longer on the table. And if you were to ask them to put it back on the table, in all likelihood, I can pretty much guarantee that if they did offer money at that point, it would be less than what they had initially offered, because now they know that you are either desperate or don't want to go to trial, in which case they now have leverage to try and offer less money, which means you are in a very poor negotiating standpoint. So, can they do this? The answer is yes, they can. But I have found that some of the best trial attorneys and the most reputable trial attorneys do not use this type of tactic. Once they make an offer, they recognize that that offer is there. And if later on you change your mind And if circumstances change, yes, that offer will still be there. And if it's not, they'll go back to their insurance company, discuss it further, weigh the risks, and then make a decision about whether or not to re-offer that amount of money. It's highly unlikely that they will offer more once that happens, but there is the possibility that they will offer less. And then you will be faced with having to make that decision about whether or not to accept this lower settlement offer, which puts you in a very poor position from a negotiating standpoint. Why do I share this great information with you? I share it with you just to open your eyes to what goes on during negotiations in these medical malpractice cases in New York. You know, I recognize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.